Okay, good afternoon, everyone.
Good afternoon.
Today's Thursday, December the 21st, 2023, and the Board on Professional Responsibility is convened in the matter of Larry E. Clayman, board docket number 18-BD-070. Will the parties please identify themselves for the record, starting with Disciplinary Council?
Good afternoon, Julia Porter on behalf of the Office of Disciplinary Council.
Oh, Ms. Porter. And Respondent?
Larry Clayman, pro se, on behalf of myself, Your Honor.
Good afternoon, Mr. Clayman. You don't have to call me Your Honor. You can just call me like Chair. Okay. So let the record show that Michael Tiger, who's one of our attorney members on the board, and Sarah Blumenthal, who is one of our public members, are both recused and will not be participating in this case. We're here on exceptions to the hearing committee report from both parties. Respondent filed the first and last brief and will argue first. We'll note that the parties should have received a communication from the board yesterday that they are expected to include in their arguments any argument on the motion to stay that was filed by Respondent on Monday the 18th, I believe. If the parties need additional time to address those arguments, they will be allowed to have that. But we'll start off with the presumption that each party will have 20 minutes. Mr. Clayman, do you want to reserve some of your time for rebuttal?
Yes, 12 minutes in the beginning and 8 minutes in rebuttal, Your Honor. Excuse me.
Okay,
Madam
thank
Chairman.
you.
Yeah.
Thank you. So we'll proceed with the argument, and the motion to stay will be decided obviously after that. Thank you.
Thank you, Your Honor. Shall I proceed?
Yes, please do.
May it please the Honorable Chairman, Bernadette Sargent, and Vice Chairman, Sandeep Hora, and every member of the Board of Professional Responsibility. I'd wanted to be here in person. Unfortunately, in the last several weeks, I've had an ear issue and I can't take long distance flights, but I thank you for allowing me to appear by Zoom. I want to get into the background of this case and then get into the case in chief. Larry Clayman, who you may know of because I'm the founder of Judicial Watch and Freedom Watch, also a private practitioner. I was a Justice Department prosecutor and defense lawyer. I helped break up AT&T as a young lawyer, and also in the last several years succeeded in preliminarily enjoining the National Security Agency over the illegal surveillance that was revealed by Edward Snowden. I've had a distinguished career, and for decades I was a member in good standing of this bar. The Office of Disciplinary Counsel became very partisan when Wallace Shipp retired and Hamilton Fox took over, along with Deputy Bar Counsel Porter. But I'm not going to belabor that here because all of that is in my briefs. And I would implore every member of the board to read those briefs. There is a tendency, I think, sometimes for members, disciplinary committees, or for that matter, any group, to rely on what other people have, in fact, looked at and determined. But I ask here because this is very important. The Office of Disciplinary Counsel, which initially recommended a 1-year suspension, which was still not warranted, has now upped the ante after the board would allow, at least for the time being, allowed this case to go forward despite a 4-year delay. Now they're asking for disbarment. So this is very, very serious. It's the death penalty. And it's important that everybody read every pleading. And I thank you for doing that in advance. Now, the case at issue involved Cliven Bundy. It was a very politically charged case. Cliven Bundy, as people may remember, engaged in a situation where literally hundreds of federal agents invaded his land in Bunkerville, Nevada, to drive him off the land. They claimed he didn't pay grazing fees. They claimed he was in violation of environmental regulations. And the government eventually left. The senator of Nevada at the time, Harry Reid, called publicly Cliven Bundy, my client, a domestic terrorist. President Obama mocked him at the White House Correspondents' Dinner. The case became very politically charged. I don't need to get into it in depth. It's in the pleadings. But Cliven wanted a lawyer who was out of state, who was insulated from those politics. And he knew that I was a strong lawyer, that I would stand up for him and the rest of the Bundy family. They were indicted as well, along with many other defendants. And few, if any, people would take the case. I was not a member of the Bar of Nevada, so I had to move in pro hac vice. I filed an application pro hac vice. It was initially denied by Judge Navarro, had been recommended to the bench by Senator Harry Reid and appointed by President Obama. She asked me for more information. I provided that information with regard to a disciplinary proceeding that had not been concluded, but which I believed at the time would have been concluded favorably in the District of Columbia. When that pro hac vice application was not granted, there was a catch-22. The judge said, well, you can come back after that disciplinary proceeding.
Allow me to interrupt for a moment. What's your basis, what was your basis for the statement at the time and your statement now for thinking that the disciplinary matter was going to be resolved in your favor when in fact there had been a preliminary non-binding determination by the hearing committee that at least one violation had been proven? So what was your basis, again, then, most importantly at the time, for saying, stating that it was likely to be resolved in your favor?
Well, number one, Mr. Walker, I'm entitled to my opinion. Number two, I did have faith that the board would rule in my favor. I also had a distinguished ethics expert that said I did not commit any ethical violation that warranted discipline, Professor Ronald Rotunda, who sadly has died. And I had perhaps a faith that things would come out in a better way. But in any event, that is my opinion. And the entire record, a large part of the record was in front of Judge Navarro. She could certainly see what the hearing committee had ruled. So that nobody was trying to pull the wool over anyone.
Well, let me follow up then and ask, did you explicitly disclose at the time in your response to the question 5 of the pro hac vice application that a hearing committee had in fact reached non-binding preliminary determination that you had committed a violation? Did you explicitly state that anywhere in your responses?
I'll go back and look and supplement, Your Honor. I didn't look before this hearing today, so I'll be happy to do that for you. But in any event, it is simply a recommendation.
Mr. Bundy, I have a couple questions for you on that matter. Your expert, who has sadly passed, as you just reported to us, I recall in your brief you say something that he had the opinion that nobody in the DC bar had ever been prosecuted for their answers on pro hac applications. Did you or your expert do a survey on that to be able to support that? Because I do believe that there's cases out there where we have had matters for individual lawyers for how they've answered their pro hac applications, to include failing to be fully descriptive of the situation.
Let me answer this question in perhaps the best way I can. I'm not aware of it, and in any event, I'm sure the facts were different in this case. But Judge Gould, who is actually, he's not ideologically akin to me, but a very honest man, one of the judges in the Ninth Circuit, found the following. And given this, there can be no clear and convincing evidence that I failed to disclose material that I should have disclosed, because there was a difference in opinion at the Ninth Circuit. So how can there be clear and convincing evidence? Judge Gould.
Mr. Klayman, Judge Gould was the dissenter, right? You had a 3-judge panel that heard that case in the Ninth Circuit. The majority issued the binding opinion, and Judge Gould was a dissenter.
That's right.
So,
but
so do you think you're relying on the statements of a single dissenter to show that there could not have been the sufficient standard of proof in your disciplinary?
Correct, because there is a difference of view on this, and therefore there can be no clear and convincing evidence. You know, the standard for clear and convincing evidence is found at Board Rule 11.05. Clear and convincing evidence is a standard higher than preponderance of the evidence. Preponderance of the evidence requires evidence which, as a whole, shows that facts sought to be proved.
Aren't you confusing clear and convincing with unanimity? That to me seems quite strange that you're that you're claiming that there's no clear and convincing evidence just because there was a dissenting opinion that was issued. Aren't you confusing that with the definition of unanimity, sir?
In all due respect, I'm not, because if there's a difference of a finding, then it cannot be clear and convincing. And besides, as I said in my briefs, I was never sanctioned by either Judge Navarro or the.
What's the difference between unanimous and clear and convincing then in your mind? And then we can move on.
Just what the rule says is it's a very high standard, clear and convincing. So you can't reach that high standard
unless everyone agrees.
In fact, a distinguished jurist said that I disclosed all that I had to disclose. That's the basis of it. And that's the argument that was made in front of the ad hoc hearing committee over 4 years ago, and they accepted that at the time. In an unprecedented ruling, they found no ethical violation by clear and convincing evidence. Now, also, I was never sanctioned by anyone in this case, not by Judge Navarro, not by the Ninth Circuit. I wasn't referred to a grievance committee of the Ninth Circuit or of the district court in Nevada. I wasn't in any way subject to a complaint by the Nevada bar or the California bar. Clearly that have happened. This occurred out of state. So there's also an issue here which wasn't briefed as to whether this bar has jurisdiction over something which happened in Nevada and was addressed there with no sanctions. And I would like to be able to file a supplemental brief on that. But in any event, the board should look into that because they reached outside of Nevada.
Mr. Klayman, let me just get to frivolity for a moment. You're also facing charges that your pleadings and your arguments to the courts, I'm saying courts by Supreme Court, Ninth Circuit, and then the district court there in Nevada, were frivolous. When I read your brief, it seems to me that, I'm looking for your thoughts on this, it seems to me that your argument essentially is that given the severity of the sentence that Mr. Bundy was facing, that you therefore were allowed and permitted under the rules of professional conduct to do a no holds bar and make any argument, whether supported by fact or law, in order to defend your client. That's what your brief sounds like to me. Can you please address that and please use the rules of professional conduct standard for frivolity and how you overcame that challenge in what you filed?
First of all, at the hearing stage, I'm the only one that had actual witnesses, myself, who had firsthand knowledge, and Professor Chemerinsky, who testified pro bono. He's dean of Bolt Hall, a very distinguished law school. He's not my ideological kin, but he came here because he felt strongly about it, and he's a good man and honest. And he testified, yes, I do think that the number of pleadings was reasonable under the circumstances of the case. This is about the ability of a criminal.
Excuse me, Mr. Klayman. I'm not talking about the number of pleadings. I'm talking about the information that was pled. So, for example, you seek the recusal of the trial court judge, and you make several arguments to substantiate why you believe she's conflicted. I believe one of them is because she was appointed by President Obama. And President Obama made comments about your client. So you're arguing that that causes her to have a conflict, that she cannot impartially decide your case. So to me, it seems that you're suggesting that any judge appointed, you must turn and look at the parties of the appointing president or those in the Senate of that state. And if they're not aligned with the defendants before that court, then there's a conflict of interest. It seems to me that's what you're arguing.
First of all,
that would suggest frivolity. So I'm looking for a little bit more detail on your position of why your arguments for her conflicts were not frivolous.
I didn't file the motion for disqualification to begin with. That was Mr. Hansen, as well as the Bivens complaint, which he dismissed on his own without even consulting with me and Mr. Bundy. But that's just background information here in terms of ideological persuasion. Just like this board is heavily skewed in one direction, it's very partisan, and so is the bar disciplinary apparatus. That's a relevant factor.
How is our board skewed in one direction versus the other?
Take a look.
How can you, if you're going to make statements like that, I think you need to sort of articulate what the basis is for that. When you say that we're skewed, excuse me, sir, let's not talk over each other. I think it makes for a better record and certainly a better proceeding. I think that if anyone asks you a question, I think I'd ask that you respectfully pause, and we'll do the same for you. So my question is, when you make an assertion like that we are skewed one way or the other, A, how are we skewed? B, what's the basis? Please proceed.
Yeah. In the last years, okay, Professor Dirksen, if I quote him here in terms of the approach of bar associations in DC and in New York, I have supported President Trump. Those who have supported him have been targeted. I'm not going to shy from this. And this is important. And as far as Judge Navarro, the Las Vegas Review-Journal, who observed the case and was present.
I just want to make sure are you done answering the question that I asked you?
Yeah,
no, I mean, because I did not hear an answer to that question. You now proceeded from talking about the trial to then talking about Judge Navarro. I just want to make sure that you finish answering the question in which you made an assertion that this board is skewed one way or the other, and I asked you for the basis of it, and then you said something about Trump, and then you went to Judge Navarro.
The very tenor of the questioning today would suggest that to me. It's very hostile, and you won't even let me finish. So I'm not going to back down from that.
So, Mr. Klayman, please go ahead. Go ahead and finish the answer that you were giving to Mr. Hora's question, and then we can.
And the very fact that the Las Vegas Review-Journal, who sat there, a neutral newspaper, hometown newspaper, government prosecutors have a friend in U.S. District Judge Gloria Navarro. That's the title, and that's in the briefs. They go on to talk about how she violated the constitutional rights of defendants, how she's trying to nullify a jury trial, etc. I was there for my client, and as Judge Gould also found, and may I read this, please, without interruption? I appreciate it. It may be that Klayman is not a lawyer whom all district court judges would favor making an appearance in their courtroom. It seems he has been, and many continue to be, and may continue to be, a thorn in the side. Still, concerns about trial judge irritation pale in comparison to a criminal defendant's need for robust defense. In providing a full and fair defense to every criminal defendant, there will be, by necessity, occasions when the difficult nature of the cases evokes sharply confrontational lawyering. In tough cases with skilled prosecutors, aggressive positions by defense lawyers are sometimes an unavoidable part of strong advocacy and contribute to making the proceeding an ultimately fair one for the defendant. So, yes.
Mr. Klayman, Mr. Walker has a question for you.
Okay.
I have this is a question in another area. And this is in regard to your arguments about the delay in the hearing, in the issuance of the hearing committee's report. And you assert harm, or you assert impropriety in that, and you ask basically that report be dismissed. Exactly, and without in any way arguing the amount of time that the board, the hearing committee took to issue that report, can you describe specifically the harm to you that resulted from that delay? And I mean specifically a statement of the harm.
Yes, well, at the end of the hearing committee proceeding, the evidence was fresh. I had testified directly based on what I had experienced. Ms. Porter, who under DC Rule of Professional Conduct 3.7 should not even have been the sole witness in the case, prohibited as a conflict of interest, did not testify and had no witnesses. Consequently, the evidence was fresh, and that was when the board, chaired by Chairman Mims, found that there was no showing of clear and convincing evidence preliminarily to hold me to have violated any DC bar rule. The evidence was fresh. Now, over time, 4 years, evidence dims and demeanor dim, and you forget. And it appears if I may answer, please respect me in that respect.
Go ahead.
Evidence dims. It looks to me like whoever wrote this draft, the first draft, simply went with the brief of disciplinary counsel. And I have issues with regard to her candid behavior, not just with me, but with regard to the Simcowitzes, if you've had a chance to read the brief. There's a pattern here. So after 4 years, not only that, I cited authority, Professor Gillers of New York University, that the more time things go on, the more prejudice will result. I cited other case law that the more time that things are delayed, there's a lesser standard to show prejudice. That is how I was prejudiced. I was also prejudiced with false statements being made by Ms. Porter and the Office of Disciplinary Counsel. And that's important. And let me make one other point, if I may, which is
let me interrupt here to say, I actually asked how you were harmed, not what the alleged prejudice was. And I want to follow up. You talked about demeanor and evidence fading. Was there actually credibility findings here that depended on demeanor evidence, or wasn't it actually? Wasn't the record all record evidence, either testimony or documents? So where does demeanor and the fading of evidence come in here? The evidence, isn't the evidence as fresh today as it was at the time? It's in the record. There weren't demeanor findings.
What happened here is that various, and I went through it, whether it's how I quoted Judge Gould, whether it was negotiated discipline, whether it's Professor Rotunda, whether it was my criminal practice experience, whether it was the trial date, whether it was solitary confinement, or whether I filed journalist findings, I discussed and testified, and so did Professor Chemerinsky, to all that at the trial. It was fresh. They could find no ethical violation. Now, comes Julia Porter and makes a number of false statements, which I've set forth in the briefs, and I hope you have an opportunity to read the record yourself rather than just accept them. And that prejudiced whoever ultimately wrote this 4 years later without a memory of what went on at the hearing. No one can remember 4 years later with exactitude. And let me make this point too, if I may, please, because this is important. And Chairman Sargent knows this full well. She was on the board rules committee. The fact is, this rule is unequivocal. It doesn't say may, it says shall within 4 years. Now, there was a case, the Morell case, which said that, okay, 4 months in a complex case is okay. The rules were revised to allow for 4 months, for 120 days. The ad hoc hearing committee never came forward and asked for an extension of time. Clearly, the board would have denied that for 4 years. This is, and you have issues beyond, you have issues. Can I finish, please?
Well, Mr. Klayman, this is an oral argument, and that means that the presiding decision makers get to ask you questions. And the question I want to ask you is, isn't this a settled question? 120 days is advisory, it's not directive. And the Court of Appeals has ruled on this. Mr. Walker's asked you how the delay has actually prejudiced you, and you've given your answer. But I'm asking you a different question, which is, isn't this a settled question?
No, it's not a settled question. And if that's the case, then maybe I'm wasting my time. Because the fact is that no one is settling a question for 4 years. That's theater of the absurd. How's that a settled question? The other case involved 4 months, not half a century. And if the board decides it wants to go that route, it has created a precedent, not just which is bad for me, but for the entire membership of the bar. You just can't sit on things for 4 years and allow memories to fade and then come up with some ruling which is a virtual identical copy of what Bar Council put forward. That's not.
So, Mr. Klayman, are you saying that, I think I understand your line of argument here. Are you saying that when the hearing initially adjourned, there was no finding?
That's correct. I'll read it to you.
Okay. So no, that's fine. I'm asking, I know that. So you're saying there was no finding at that time.
Yes. And you know how rare that is, Your Honor. You know how rare that is.
Right. And you're saying the final report came out 4 years later, and that is your prejudice, that at the time you feel like you won because there was no finding.
It's not what I'm saying.
Is that what you're saying? It's not what you're saying.
I'm saying that in part. What I'm saying is common sense, Your Honor, and the way things work. And I cited the authority of Professor Giller's and case law, is the longer a proceeding goes on past the time of the trier of fact listening to it, memories fade. Memories are not what they were at the time. What they were at the time was what Chairman Mims of the Ad Hoc Hearing Committee and the others found. It is extremely rare, you know, to not find any violation at a preliminary phase. We had just gone through several days of testimony. I laid out all the pleadings to answer the question of one of the other esteemed members of the board. I mean, no disrespect, you know, in my pushing back here. but I have to. I'm representing myself. I can't afford to get a lawyer because of all that's going on with this disciplinary council. And the fact is that at the time, they had it all in front of them. They went out, they deliberated, said, we can find no ethical violation. That is almost unheard of. Yet 4 years later, all of a sudden, the recommendation reads like Julia Porter's brief. Now, something happened in the interim. Now, we also know, I know the way it works. I've been involved in litigation a long time, and I've been involved, unfortunately, with this bar. You know, people talk in the interim period. You see each other at parties, you see each other at other events, whatever. I don't know what.
Mr. Klayman, so would you like to address your motion to stay argument? I'm not trying to cut you off, but it sounds like your arguments are going, going in that direction.
That's what I'm saying, okay? Is that I'm asking for an internal review. First of all, I'm asking you to dismiss the case as a matter of law on the delay and on the merits, but then I'm saying also conduct an internal review with regard to the false statements that were made by Ms. Porter that prejudiced the ad hoc hearing committee 4 years later when they finally got around to writing the recommendation, and with the fact that what happened in that interim 4 years to change this thing 180 degrees to issue a recommendation which could effectively end my career in the District of Columbia.
Do you have any specific allegation of a particular alleged communication between anyone from the Office of Disciplinary Counsel that would have prejudiced you in the ultimate decisions that were made?
That's why we needed an internal review. And with regard to Ms. Porter, it had previously been ordered by Chairman Bernius, and then it was put onto the table by the subsequent Chairman Kaiser, who never followed up. Now, I laid out in that motion a number of false statements that were made by Ms. Porter. I would respectfully request that you look at that. And that is what prejudiced the committee 4 years later, because they picked up her brief. Okay, 4 years later, what did they do in the 4 years? They didn't feel like working? What was the reason for that? Well, it's easy. I'll just copy what Office of Disciplinary Counsel writes. And that's what happened. So
Mr. Klayman, do you have case law for us that you could provide that gives the directive that we're to dismiss cases if the report is not written within 120 days? Do you have a case for us on that?
I'll be the case, because unfortunately, this board and the court doesn't respect its own rules. They promulgate rules, but they don't apply, particularly when someone like Larry Klayman is involved. We'll forget about the rules for Larry Klayman. We don't like the way he is or practices law or how he, clients he represents. But for Larry Klayman, we'll forget about the rules. And that's not right. That's not right for anybody. Whatever. Either you have rules or you don't have rules. And there's also the doctrine of latches. In a case called Williams, which I cited, 513, Atlantic 2nd, 796, District of Columbia, 1986. Doctrine of latches would also apply here. Now, you don't get to make the rules up as you go along. You have a rule. It doesn't say may, it says shall. And there's a reason for that, to avoid delay and to avoid prejudice. And the 4 years is beyond unconscionable. That's half a century. So, I think you have to do it, not for Larry Klayman. You may like me or you may not like me, or you may not approve of who I represent or what I stand for as the founder of Judicial Watch and Freedom Watch. But you have to enforce the rules fairly and equally. There's no court opinion out of the District of Columbia Court of Appeals that says 4 years, a half a century is okay. The rules are the rules.
All right. Thank you, Mr. Klayman. You've got 8 minutes on rebuttal. Ms. Porter, are you ready to proceed with your argument?
Yes. May it please the board, Julia Porter on behalf of the office. Whoops.
Can I ask all the participants to put themselves on mute? I notice Mr. Fox is on, and I think your mic might be open. Thank you. Okay.
All right. May it please the board. The hearing committee found that Mr. Klayman made numerous false statements, many of which repeated. It was not limited to his initial pro hoc vice application. Rather, those misrepresentations, those false and misleading statements continued for over 2 years. hearing committee also found that Mr. Klayman filed baseless or frivolous actions, took retaliatory actions against the judges the trial judge who had ruled against him, and later the Ninth Circuit judge who had authored the decision. He made up facts to accuse them of bias and prejudice. And in the
Miss Porter, on going to your statements regarding Mr. Klayman filing frivolous actions before district appellate and arguably the Supreme Court, can you please list for us with specificity what ODC believes were the frivolous motions? Like what was frivolous, both why it was frivolous under fact and or under law with some specificity?
I can start with the Bivens complaint that Mr. Klayman filed against the trial judge who he sued after she denied his pro hoc vice motion. The Bivens action was legally without basis and factually without basis. And I think the hearing committee delineates a number of the allegations that Mr. Klayman made in that Bivens complaint, which were again repeated in the motion to disqualify, which was also a frivolous pleading, including
Miss Porter, could you flesh that out a little bit for us? In the Bivens series of filings, how was it frivolous related to law, and how was it frivolous related to facts? Like what was missing that met the burden of this being frivolous activity on the part of Mr. Klayman under our rules of professional conduct or under the Nevada rules of professional conduct?
Sure. You can't sue a judge for prejudicial acts under Bivens. And that's exactly what Mr. Klayman did. Not only did he sue her, but he sued her for damages. Initially, 50 million, and then it was later increased to 90 million. A Bivens actions against a judge who is ruled against you is frivolous as a matter of law. As a matter, the factual averments that Mr. Klayman made in both the Bivens and the motion to disqualify were also baseless and not and were frivolous, including that the Judge Navarro was biased and prejudiced against him for, among other things, because I think he described her as a Latino woman Democrat, and therefore could not possibly judge his motion for pro hoc vice or the Bundy matter, and therefore had to be disqualified. He made other allegations against Judge Navarro, including that she was basically the benefactor of President Obama and Senator Reid and was basically doing their bidding. Again, no reasonable lawyer would think that that would have any chance of prevailing, and it had no factual basis other than a conspiracy-minded, theory on the part of Mr. Klayman, which had no factual basis. There were other allegations that Mr. Klayman made in both the Bivens motion and the motion to disqualify, which he repeated in other briefs to show that Judge Navarro was somehow biased or prejudiced, including claiming that Judge Navarro had ordered that his client, Mr. Bundy, be either kept or put in solitary confinement. Again, there was no factual basis for this. And Mr. Klayman was well aware of that because Judge Navarro, the prosecutor, and even the Ninth Circuit said there is no factual basis for that. That was not the only claim that Mr. Klayman made that had no factual basis to basically impugn. Sorry.
I know that you're responding to Ms. Cassidy's question, and it's a good question and needs fleshing out. But while you have talked about the matter of the allegation or the statement that Judge Navarro had ordered that Mr. Bundy be placed in solitary confinement, Mr. Klayman has testified that Mr. Bundy essentially told him that the judge had ordered him placed in solitary confinement. And he also testified that Attorney Whipple essentially reported to him that the Judge Navarro had threatened to hold him in contempt. But you didn't call either Mr. Bundy or Mr. Whipple as witnesses in your case. The respondent, Mr. Klayman, has basically asserted that in failing to do so, you have shifted the burden to him to disprove his dishonesty on those 2 points. Why is he wrong in making that argument? You did not call either of them, and the record includes Mr. Klayman's testimony and just his testimony on those points. So how is he wrong?
All right, if I can, I'll try to answer both of those questions. First, just because Mr. Klayman testified about something does not mean it's true or credible. With respect to Mr. Bundy being put in solitary confinement, we put in the transcript of the hearing where Mr. Klayman was in attendance, where where the issue was raised, or the question of Mr. Bundy's confinement was raised, and Judge Navarro and asked Mr. Hansen and Mr. Bundy, who are sitting at council table, and they represented that Mr. Bundy was in solitary confinement, or he had asked to be segregated from the rest of the prison population for his own safety. Mr. Klayman was present when that representation was made. He knew that Mr. Bundy had requested this. And in subsequent pleadings, it was reiterated by the government, and Mr. Bundy never said anything otherwise on any public record. But yet Mr. Klayman repeated the statement over and over again, knowing it was false, in order to bolster his claim that Judge Navarro was somehow biased or prejudiced. With respect to the Mr. Whipple being held in contempt, again, there is overwhelming evidence, including statements by the judge, by the prosecutor, and absolutely nothing in the record indicating that this ever occurred. The fact that Mr. Klayman said he heard it from somebody who also doesn't have anything in the record doesn't mean that that is credible or believable evidence. And the hearing committee didn't credit it.
Did the hearing committee find that that was not a credible statement?
Not explicitly, but they didn't credit it. So yes, implicitly they did. And there's other instances where the hearing committee did make adverse credibility findings against Mr. Klayman, including about his involvement in the Bivens complaints and the motion to disqualify. The hearing committee found that Mr. Klayman's testimony at the hearing and some of his representations, where he tried to disassociate himself or deny responsibility, were simply not credible, given all the facts and circumstances, including the very pleadings with his name on it as of counsel, and his admission that he helped prepare them, if he didn't prepare them almost entirely himself, approve their filing and everything else. So yes, the fact that Mr. Klayman says something or testified to something at the hearing doesn't mean it's true when there's overwhelming evidence in the record to refute it. And that applies to a number of the other misrepresentations and misleading statements that the hearing committee identified in its report, including about Mr. Klayman's, statements about his experience and the fact that the lawyer who was representing Mr. Bundy had no federal criminal law experience. Those were, as the Ninth Circuit found, blatantly false characterizations. The hearing committee, I think, lays out in detail a number of the false representations and misleading representations that Mr. Klayman made in the case. It started with the motion to... I'm sorry? Oh.
Again, if everyone who's not speaking, please put your microphones on mute.
Okay. It started with the motion for pro hoc vice admission, but it didn't end there. It continued for over 2 years. In addition, there was the retaliatory and frivolous actions he took against Judge Navarro initially, and then the judge on the Ninth Circuit. As the hearing committee found, he also seriously interfered with the administration of justice, not only by making false and misleading statements and doing so repeatedly, but by the frivolous and retaliatory actions he took, and the fact that he filed or raised these issues over and over and over again, notwithstanding that they had already been reviewed and decided upon by the Ninth Circuit and the Supreme Court. I would like to focus on Sanction 2. Disciplinary Council has requested that the board recommend disbarment in this case. Disciplinary Council, when it made its initial sanction recommendation, we said at least 1 year with fitness. That was before the court ruled in Claimant 1, where it issued a 90-day suspension, and in Claimant 2, where the court issued just relatively recently an 18-month suspension with fitness. The hearing committee did not consider Mr. Claimant's prior discipline. The board should and indeed must in recommending a sanction in this case. This is the third matter that is going to be coming before the court.
Porter, are you arguing that we should treat the previous matters involving Mr. Claimant as aggravating factors here in the sanction analysis?
Yes, I mean, that's what the board has been, the court has said that you look at all the matters as if they were before the board. But yes, prior discipline has always been an aggravating factor.
So are you then, is it askew that you're citing when saying we look at it all as one? Because in askew, doesn't the court say you don't, since these matters were pending in the disciplinary system at the same time, we don't look at the previous two as actual aggravating factors, do we? We look at the conduct as if it's all before us at one time. Is that right?
Well, I don't know if they're what you're saying is that different, but Spates is another case where the court, the board basically doubled the sanction recommended by the hearing committee because there had been a previous case that the court had then decided against Mr. Spates. So yes, I'm either whether you look at all the misconduct as if it was before you or consider the prior misconduct, which is that now is prior misconduct, as an aggravating factor, I think you get to the same place. But you don't.
What about the fact that the board that in what's I'll refer to as Claimant 2, the sanction there took into account Claimant 1. So if we look at 1 and 2 separately and re-aggregate them, aren't we double counting Claimant 1 again then? Shouldn't we just look to what occurred in Claimant 2, since I believe that took into account the conduct in Claimant 1?
Okay, well, that's a good point, but I think it still gets you to the same place, and that is disbarment. Even if you consider only Claimant.
Then can you tell us what cases can you cite where there's comparable misconduct as is before us here, even following what we're supposed to do and ask you? What cases can you cite that get us to disbarment for this conduct? For example, in Shea, which I think you cite in your brief, that conduct involved 3 counts of criminal contempt, where the finders, the relevant authorities talked about instances of moral turpitude. We don't have that here. So what cases can you cite that get us to disbarment in this matter?
2 of the cases that were cited in the hearing committee's report, I think, would be instructional, and that is In re Baber and In re Barber. I'd also note that Mr. Rosen, another case cited by the hearing committee, involved a single reckless misstatement, and Mr. Rosen got a 9-month suspension with fitness. The misconduct involving just the Bundy case, just the case before you, is far, far worse than what Mr. Rosen engaged in. As the hearing committee found, Mr. Claimant involved in repeated dishonesty, and the hearing committee also considered the fact that there was no acknowledgement, no remorse. To the contrary, Mr. Claimant says he would do nothing different, and indeed has engaged in the very same misconduct in the Robles case, which the hearing committee discusses and cites, but also in these disciplinary actions, including up to last week, where he's basically threatening to sue the board if it doesn't dismiss or render null and void the hearing committee's report because it wasn't issued within the 120-day deadline or time period set forth in the board and court rules. And maybe this is a good segue just to address Mr. Klayman's motion on that. And the law is settled. There's never been a case where the court has said that the hearing committee's failure to comply with the deadline is a basis to dismiss the case or even to mitigate sanction. Unfortunately, cases sometimes do take a long time, but I'd also note that the hearing committee, when it said it was unable to make a preliminary non-binding finding at the end of the hearing, said in January of 2020, which was more than 3.5 years ago, that they had reached a preliminary non-binding finding. And there was a subsequent hearing on mitigation and aggravation, which Mr. Klayman managed to postpone for a while, but that was held in September of 2020. So this notion that there was a finding of no misconduct and then 4 years later, that's just not true. In January of 2020, the hearing committee had made that preliminary non-binding finding, and Mr. Klayman has not articulated any prejudice from the fact that it took the hearing committee 3 years after the mitigation and aggravation hearing, and which was more than 9 months after it had made its preliminary non-binding finding, to issue its report and recommendation. If anything, Mr. Klayman is asking for treatment that no other respondent has ever received, because unfortunately, hearing committees in contested cases very rarely issue their reports and recommendations within that 120-day deadline.
Ms. Porter,
Sure.
to go back to the sanction and what impact Klayman 1 and Klayman 2 should have. Do you know off the top of your head from the record, chronologically, when are we talking about this conduct having occurred? So in other words, in time, did the Bundy events occur before the events in Klayman 1 and 2? You know what I mean? Or is it only relevant for us to look at when Klayman 1 and Klayman 2 were finalized, as opposed to when that conduct actually occurred?
I don't know if I can give you precise deadlines as far as when the conduct in Klayman 1 occurred and when the conduct in Klayman 2 occurred, but I think it's an important fact that the misconduct in the Bundy case all occurred while he was either under investigation or facing charges in the other two matters. So usually, I guess a lawyer's experience or, dealings with the disciplinary council will make them, I guess, more attuned to their ethical obligations. This obviously did not occur with Mr. Klayman, because as the hearing committee found, for over 2+ years, he engaged in serious dishonesty, filed retaliatory and frivolous actions, and abused the process. That, I think, is another aggravating, or disciplinary submits that is another aggravating factor that this board should consider in recommending sanctions. As the hearing committee found, and they were very troubled by the fact that there is no indication that this misconduct, the type of misconduct that occurred in the Bundy matter, is going to stop. There's been no remedial steps by Mr. Klayman. To the contrary, he continues to make baseless allegations against anyone who has the temerity to rule against him or take action against him, and accuse them of misconduct and claim that it's all politically motivated. There's no basis to Mr. Klayman's actions, and they should not be rewarded. To the contrary, they are also aggravating factors that this court should consider in sanction, and that sanction should be disbarment.
Do you have anything to add to your papers with regard to the motion to stay, Respondent?
No, I think we filed a written response, and I guess I commend the board's October 11th order addressing the issues that Mr. Klayman has now re-raised.
Okay, thank you, Ms. Porter. Mr. Klayman, you have your time for rebuttal.
First of all, Professor Chemerinsky is a constitutional law expert, also a professional ethics expert, dean of Berkeley Law School, testified that judges can be sued under Bivens for injunctive relief in particular. So therefore, it was not frivolous. Secondly, and this was another lie by Ms. Woodruff, and I'm going to call it what it is. She says, I filed the case. I didn't file it. The local council filed it. And for continuing to represent that I filed the case, it's false in another state. So, and she should be sanctioned, and she should have bar proceedings instituted against her. But unfortunately, this board and the court has given itself absolute immunity, and that issue's up on appeal now to the DC Circuit. You don't have absolute immunity. No prosecutor has absolute immunity, particularly when it's not legislated by the DC Council. So consequently, that's why I asked for internal review. And I hope that you'll have an opportunity to look at the false statements that were made and look at the record, because this is what's been going on, not just with regard to me, but also the Simkowitzes and others. I'm sure there are many complaints in the files about people who've been victimized by Ms. Porter. I'm going to defend myself. And the fact is that I can go through each one of these statements. First of all, they're not material. And I'll go through them one by one with regard to what we said in pleadings, which, by the way, I didn't file. That I cropped a Gould quote. I used the Gould quote that he said I disclosed all I needed to, and that I was a strong litigator. Negotiated discipline. That was withdrawn. The affidavit is of no force in effect, except if the case goes on for impeachment. That's it. And I felt that I had made an agreement which was not just. So it was withdrawn. And in fact, Disciplinary Council withdrew it too. With regard to criminal practice, I was a Justice Department prosecutor. I represented the Food and Drug Administration. We had a number of criminal cases. I've represented
Mr. Clayman, how many criminal trials had you had at the time that you were seeking to be admitted pro hoc vice in the Bundy matter?
I had a criminal trial before Judge Lamberth, which was a criminal contempt trial. And with regard to two matters in Florida, we were able to resolve those without going to a trial. Okay, but that doesn't mean you don't have criminal experience or you don't take courses on CLE. And it doesn't mean that you don't know what's going on. And that was my opinion, that I had sufficient criminal experience. And here's the other thing.
Mr. Clayman, following up on that then, could that not be said of Mr. Whipple as well? Did he not have substantial criminal experience taking matters to trial, such that your statements regarding his career were inaccurate?
It didn't appear to me that he had real experience. To the extent he did, his specialty was DUIs and immigration matters. And
excuse me, Mr. Clayman, though, we haven't heard in your recounting of your career that you had experience of the sort of matters, crimes that Mr. Bundy was facing. So could that not be said of you then as well?
Could have been said of me, but nobody said it and nobody sanctioned me. Never been said.
I'll restate my question. Excuse me, Mr. Clayman, if your position is that Mr. Whipple was not qualified, incompetent to represent Mr. Bundy because his experience were of the sort of criminal trials in state court, and therefore he's not fit, yet you yourself had not, even today recounting for Ms. Sargent, told us of a matter akin to the Bundy case that you handled. You told us about an antitrust case with AT&T, and then you told us about some FDA matter. Neither of those are akin to the Bundy case.
I handled a case of criminal contempt against people in the Clinton administration before Judge Royce Lamberth. I'll submit the case site for that. It was quite a lengthy proceeding, which lasted many, many weeks. And the fact is that Mr. Whipple was fired by Mr. Bundy. There's testimony in the record of a hearing in front of the magistrate judge where he said, I wasn't prepared. I never advised Bundy of his rights here to a sufficient degree. Bundy testified to that. He was fired. He wasn't doing his job. Also, I raised a petition for writ of mandamus with him that he could file that in a particular matter. He didn't know what it was. I couldn't imagine that if he had steep experience in the law, criminal or civil, that he wouldn't know what that was. But here's the basic point too, is that none of these things that are being thrown out now ex post facto by Ms. Porter are material. None of these representations, true or false, were made in the District of Columbia in any District of Columbia case. In the jurisdictions where I was seeking pro hac vice entry, Nevada and California, no one sanctioned me. Even Judge Bybee didn't sanction me. He didn't refer me to the grievance committee of the Ninth Circuit. He didn't refer me to any bar association, didn't refer me to the District of Columbia bar or any other bar.
Mr. Clayman, what is your authority for asserting that if you are a DC barred attorney, but you commit misconduct in another jurisdiction, you can't be disciplined in DC? What is your basis for that, for that kind of thinking? It seems to be a disconnection there.
You're
saying that you can commit misconduct in some other jurisdiction,
First of all,
there's no the DC disciplinary system can't review and treat that.
Number one, I didn't commit this conduct in the other jurisdictions. Okay, I wasn't sanctioned. I wasn't referred to grievance committees. No bar took it up. Consequently, there's precedent for the DC bar not to get into this matter, except for the fact that the Office of Disciplinary Counsel has an agenda. I've set it forth in the briefs, whether it's me.
Mr. Clayman, we understand your concerns and the arguments you're making around agendas. But I think the question is this: what is your case law to support the fact that a DC lawyer entering the jurisdiction of another bar can commit misconduct, assuming arguendo, they commit misconduct in another bar, that the DC bar cannot prosecute them? Can you please give us a case citation that supports that supports that proposition?
It's not in my briefs, but I will supplement with that. Also, there's a thing called prosecutorial discretion. Let me add one other thing, because there were other false statements made by Ms. Porter.
While you're looking
one and claiming two, may I finish, please?
Mr. Walker has a question.
Just want to make clear that my question was based on, should have said, if you allegedly committed misconduct, as Ms. Cassidy said, assuming arguendo that you did, not having decided the issue here. But go ahead, please.
Mr. Clayman.
It's important to recognize that in claimant 1 and claimant 2, there were specific findings that I did not engage in dishonesty. In claimant 1, there was no reinstatement requirement to it. In claimant 1, which was a conflict of interest, Judge Royce Lambert said the issue of my conflict of interest was ambiguous. And I asked him in front of the committee at the time, did he refer me to the DC bar? He said, no, I didn't believe that it rose to that level. I referred many people to the DC bar for what they've done. He came voluntarily to testify, Judge Lambert. In claimant 2, I had Judge Sporkin testify that I was a person of ethics over the many years that I practiced in front of him. I'm challenging claimant 2, and it's in your record with a Rule 60 complaint, because there was, as I allege, and I'm entitled to do that, I'm entitled to seek to set aside that suspension. So that should not be considered until that runs its course. The case is running its course in the Superior Court of the District of Columbia. And what occurred there, as I allege, and I hope you'll read that complaint, was perjurious testimony, suborning of perjury, and a denial of due process by not allowing into the record matters that had become obvious but had been buried by Office of Disciplinary Counsel during the proceeding. So that case is a live case, and I strongly contest that. Now, this case, in terms of disbarment, what has been done here, because I have a suspension from claimant 2, which is the Sataki case, which again is being contested with the Rule 60 complaint in the Superior Court. That suspension will come off on March 17th of next year, 2024. So what has occurred here, whoever conceived of it, is called stacking. Now, the Florida Supreme Court has held that you can't hang back, in this case for 4 years, and not proceed with your case, to only at the point that another suspension comes undone or no longer active, then stack it on, to then pile it on. The Florida Supreme Court has ruled that to be unconstitutional and improper and unethical. And that's what is also occurring here. So whoever came up with this concept, and that's why you need an internal review, this idea that you're going to hang back for 4 years and wait for claimant's other thing to come.
Well, what is your evidence that the Office of Disciplinary Counsel deliberately hung back on this
Not just the disciplinary
related
council,
matter?
but the ad hoc hearing committee as well. And I know that
What is your evidence of that?
Res ipsa loquitur, the facts speak for themselves. Who, Your Honor, who, Madam Chairman, would wait 4 years to issue a report and recommendation unless they were not hanging back, or unless there was some other untoward activity that was occurring? And this is, Your Honor, and I was a proud member of this bar, and still am, I'm still a member of the bar, for 40 some years. Okay? And, you know, I got to tell you something, not just for me, but for others. I'm not the only one who's been treated this way. Not by Ms. Porter and not by Hamilton Fox. And you had a disciplinary counsel who had integrity, and that was Wallace Shipp, and he retired. This disciplinary counsel and Ms. Porter have a partisan agenda to eliminate conservative lawyers and Republican activist lawyers that they don't agree with. And it's not for them to decide how I practice law. They are not God. You know, I spent 4 years getting my degree, undergrad, and then 3 years of law school. I practiced for, now it's going into the 46th year. I've had a distinguished career. I have succeeded at many things that I've done. I cited just a few examples. And they don't get to decide that Larry Klayman should practice law in the way they would practice law. If they were practicing law, they would be representing the clients that I represent. Very controversial clients. They wouldn't be suing presidents. And by the way, I've been nonpartisan. I sued George Bush. I sued others as well, because I believe that people should be treated equally and fairly. And I have not been treated equally and fairly. And I have never been accused of being dishonest in any disciplinary proceeding, except when Ms. Porter decided she had to conjure up reasons to try to get me disbarred. And I respectfully request that you look carefully at what she claims I said was false, because it was not. And if not, it was inadvertent at the time. Things were happening. And number two, that you look carefully at what she said in her briefs. And I cited at least 10 to 15 examples of false statements, including that I filed the Bivens complaint. Nevertheless, Professor Chemerinsky, Dean of Berkeley, said that it was reasonable. Now, he's not somebody who's on my ideological side of the fence.
Thank you. Thank you.
Man.
Yeah. Thank you, Mr. Klayman. If there are any, are there any other questions from any of the members of the board? Thank you very much, counsel. Mr. Klayman, thank you very much, Ms. Porter. We're adjourned and we'll take this matter under advisement. Thank you.
Thank you.